Hello everyone and welcome back. In this video, I'm going to talk to you about the Baker Act and your constitutional and statutory right to seek relief when you are or your loved one is being held illegally. So we had an issue with an individual we were representing, young man, early 20s, who was taken to a Baker Act facility after he'd been at a hospital for a medical issue. And the facility didn't want to let him go. So the family hired us. We filed our petition in court to have him released. And at that point, the facility sort of snubbed their nose at the petition. They snubbed their nose at the court and said to the family, I don't know why you spent this money on a lawyer, because it's up to the doctor to let your loved one go. And there's nothing you can do about it. And we don't care about the lawyer and we don't care about the court, and we're going to do whatever we want. And I said to the family, I said, look, first of all, I said, I think that's extremely unprofessional. And frankly, I think it's bordering on unethical. I said, but more importantly, I said, the Florida Constitution and the Baker Act statute itself guarantees your right to seek redress in court when we believe that your loved one is being held illegally. And clearly in this particular case, he was being held illegally. Not only that, they were trying to coerce him to sign a voluntary admission agreement. And I've talked about that, for hours on end, right, with different videos. But the bottom line is with the voluntary admission is you have to, if you give consent, it has to be informed consent, and you understand what you're signing. Okay, and the hospital wasn't going to do that. They just said, sign here, or you're not getting out. Take these medications, or you're not getting out. Well, he didn't want to take the meds because he already knew that he didn't need them. And more importantly, those medications typically render a patient catatonic. In other words, they give the facility evidence to go to a court and say, oh, judge, you can't let him go. Look at the condition he's in. Well, yeah, because you medicated him and rendered him catatonic. And so I said to the father, that's fine. If they want to play that game, no problem. I'm happy to entertain them. I will see them in court. And so after our case got accepted by the court and assigned to a judge, we had the court set the matter for a hearing. And wouldn't you know it, at that point, the facility said, you know what? We can't be bothered with the aggravation. We're not going to deal with this. We don't want to have to come into court and explain ourselves. Yeah, I bet you didn't. Because I would have called the doctor if he didn't testify, and I would have cross-examined him and had him explain why he was coercing our client to sign a voluntary admission agreement, to agree to take medications that were clinically inappropriate, and all the shenanigans that went on, not least of which was telling the family they didn't get the facility and the doctor didn't care about the courts or the lawyer, and it didn't make a difference. It makes a difference. It makes a very big difference. And having handled, close to, I don't know, at this point, we must be over 500 of these cases, and had my own family member Baker acted, I'm very happy to fight these facilities, because what's going on here in Florida is shameful. And the system here, the mental health system, is draconian and broken. But we're here to help families when your loved ones are getting stuck in facilities and they're being abused and coerced and threatened. We would like to help you. And so that's my 2 cents for today on the Baker Act. I appreciate you tuning in. I'd love a thumbs up. And please, if you could, subscribe to the channel. And I will see you in the next video. Bye-bye.